Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy. They're not saying TikTok has to stop. They're saying that the Chinese have to stop controlling TikTok. So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again, Mr. Chief Justice, if I may, let me separate where you started, which was the content manipulation, and then go to the data security part of it. So,
well, the first part was not. I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's data?
They've got all the information, whatever algorithms they want, that has access to the personal information, or at least information that is not readily available, about 170 million Americans. And whether they're going to use it in 10 or 15 years, when those people grow up and have different jobs in different places, or whether they're going to use it now. That, at least as I look at the congressional record, is what Congress was concerned about.
Well, I think
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think to answer your question properly, I think I have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos or dance videos doesn't affect national security. No matter what happens, the only thing that can affect national security are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says what we're really worried about is sowing doubts about U.S. leaders, et cetera. So let me turn then to data security. Yes, there were various congresspersons, and in the record that we have in the D.C. Circuit, there were conversation about the problem of data security here. As I said, I don't dispute that that is a valid governmental interest. So I think you addressed whether that alone can sustain the act in two steps. First, you would ask, if you have an impermissible motive and a permissible one, can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions, like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it, and every bit the connection?
Does Congress have to go